Hello, and thank you for joining today's webinar about the legal threats of food traceability. I'm Angela Ferguson, and I'm with ReposiTrak. Today, we're happy to welcome back Shawn Stevens as our host. Shawn is a food industry lawyer and founder of Food Industry Counsel, LLC, a law firm based in the U.S. that represents the food industry exclusively. As a food industry consultant and lawyer, Shawn works with the world's largest growers, processors, restaurant chains, distributors, and grocers to help them to protect their brands by complying with FDA and USDA regulations, reducing risk, managing recalls, and defending high-profile foodborne illness claims. Shawn also speaks regularly to national and international audiences on a wide variety of scientific, regulatory, food science, and legal trends. You can learn more about Shawn and his organization at foodindustrycounsel.com. That's counsel spelled C-O-U-N-S-E-L. Shawn is a resource that you can call on any time without the need for a retainer. His contact information is on the screen now and will also be provided at the end of our presentation. Just a few housekeeping notes before we get started. Today's event is being recorded. An email will be sent out within 24 hours to each person here today, as well as to anyone who registered but could not attend. We are saving time for questions at the end of Shawn's presentation. If you have a question, please type it in to the survey or the question panel on your screen. And at the end of today's event, we will have a quick survey that pops up on your screen. So please take a moment to give us your thoughts and to let us know if you'd like us to contact you about food traceability for your organization. So with that, I'll hand it over to Shawn.
Thank you so much. And thanks everybody for joining us today on a topic that is, I would say, crisscrossing the headlines in the food industry, and that's traceability. We're on the edge of huge changes in the way we sell food and distribute food in the supply chain with respect to the new regulations that are soon going to be in effect. So this is a very critical time, I would say, for anybody in the food industry who is dealing with food products on the food traceability list, and it really is going to change all of our lives. And I think sooner than any of us really anticipated, because once the rules go in effect, right, we have to make sure that we're compliant and that FDA is satisfied if they conduct an inspection. But in the meantime, we have to get there. And that really is what today's talk is about. I want to do a couple of things in today's presentation, because I think one of the challenges we as industry have when it comes to traceability is we're sort of, a lot of companies from my perspective have been sort of just sit and wait approach, hoping perhaps maybe the rule won't be enforced, hoping perhaps the rule, FDA will change its mind and change direction and say, listen, this traceability thing is too difficult, we're not going to do it. But that's not going to happen. One thing is certain: when it comes to the regulatory agencies, the one thing that is certain is that they will continue to grow, the regulations will continue to develop, and you have sort of that balloon effect, right? And when we're talking about traceability and the compliance state, which is fast approaching, one of the things I think we have to keep in mind is what happens after the deadline, right? How many additional foods will be added to that list? And I think we are eventually going to see ourselves at a place where every single food that is sold in this country will be subject to new and enhanced traceability rules, and perhaps the traceability rules that are going to affect with respect to the high-risk foods. So the legal challenges, today's talk is going to be, I want to do three things. I want to talk about Part 204 and what it means, right, for us. Now, this isn't a talk about how to comply, but I want to just kind of set the table, talk about the framework, some of the basic requirements, just so we're level set. After that, we're going to talk about cucumbers, okay, how cucumbers factor in, and then we're going to talk about the legal consequences of not complying by the due date, and what can happen to us and our food companies and our brand if we haven't achieved compliance under the rule. Now, I borrowed this slide from ReposiTrak because I think it kind of tells the story. You know, we're 1 year out, 10 months, 26 days and 11 hours from the deadline by which we are expected to be in compliance with the new traceability rule. And this regulation is really unlike any others we've seen in the food industry, because in order to comply, everybody has to comply, right? If we're somewhere in the middle of the supply chain and upstream, our suppliers aren't doing what they're supposed to do, it's going to make it impossible for us to establish compliance in each of our customers, right? So we really, we say that, food safety is not competitive. This is a prime example of food safety not being competitive to the extent, right, we need to work together, share resources, adopt systems, right, that talk to each other up and down the entire supply chain so that we can all, with the united front, reach compliance. Now, when I look at, the 1 year, 10 months, 26 days and 11 hours, my mind goes back for a couple years. Just think about it. November 15th, 2022, the rule was passed, right? The regulation was put into place, and FDA gave us 4 years, in essence, and some change to achieve compliance. And when we look around at the food industry, there's a lot of companies who really haven't taken that first step yet. We're starting to talk about it, right? Because it's getting much closer, but there's a lot of companies that haven't taken that first step. And this is the time, right, that we need to lean forward in the food safety foxhole and begin thinking about how we're going to get ourselves into that compliance silo. So November 15th, 2022 has long passed, right? And remember, it was just like 4 years. We've got time, eventually we'll start talking about it. We'll talk about it at conferences. We'll do webinars like this, and we'll worry about it later. Well, November 15th, 2023 has now also passed, right? And we're a number of months now into 2024. And before you know it, time flies. And it seems that every year I get older, the days go by even faster. Pretty soon, we're going to be just, on the forward edge of the holidays here in 2024. And that's going to leave us with not a whole lot of time, right, to achieve compliance. And it would be a mad dash if we wait that long. So it's critically important, I would say 22 months, I think it is, that we really think about, and when I say we, I mean us collectively, all of us, think about how we can help each other, right, to get across the finish line. So I used the slide in the last webinar I gave, was I think in December, about actually what the rule requires and how we can achieve compliance. And again, this is going to be a lot more high level, but the purpose of this slide is just to illustrate the frustration that a lot of folks in the industry are feeling, because they don't really know where to go. They don't know where to turn. They don't know what is a good solution. Part of what the discussion, I think, needs to be, in addition to how do we comply with the rule, is what is the best means to get there. And of course, I think it's very important for us to understand in our organizations, as we think about allocating resources and we think about how we need to staff, manage, and then execute our programs, to have a very frank and open discussion about what the legal consequences might be if we don't get there. There's certain regulations where if we don't achieve compliance, let's say it's a labeling issue, maybe we have some class action exposure, maybe FDA shows up and writes a letter expressing their dissatisfaction. But this is a different world, right? And we're going to get into sort of the purpose behind the traceability rule. And the purpose really is to save lives. So this isn't one of those rules that the FDA is going to take lightly or kind of look the other way and execute regulatory enforcement discretion with respect to enforcement, because the purpose of the rule is really to ensure the public health. And if food companies aren't there, haven't crossed that line by the deadlines, the agency, I would predict, and I've been doing this for 25 years, will be very aggressive and very forceful in the regulatory enforcement actions that result. There's also additional exposures, including civil liability And we're going to talk a little bit about criminal liability as well, with the very public announcement by FDA and DOJ, now, well, 10 years ago, that in the event individuals, people, consumers get sick, FDA will look very closely at if there's a basis to refer those matters to DOJ for additional investigation and potential criminal charges. And all of this stuff is woven into, right, not only preventing foodborne illness outbreaks, but also helping the agency identify the source of outbreaks as fast as it can to prevent people from getting sick. And if we aren't there collectively as a group achieving compliance under the traceability rule, that means more people are going to get sick than otherwise would have, and the agency will treat that extremely seriously. And we'll get into sort of the details about what that means. Now, I just got to give some kudos to Frank Yanis, the architect, so to speak, him and his team, right, at FDA, for putting together the traceability rule and requirements. And before he left FDA, he made sure that this rule was unveiled and introduced. And yeah, he did do that. And Frank, I'll say he's at his time at Walmart was really a champion of traceability and understood in his core the importance of traceability and protecting the consuming public. The faster, when we find out that there's an issue, the faster we can figure out the source, contain it, and then eliminate it, the better off for all of us, not only us as professionals, but also us individually as consumers and our families and our friends and our neighbors. So what is the purpose of the Food Safety Modernization Act, passed in 2011, signed by President Obama? It was really Congress screaming to FDA to make foodborne illness stop. That's the legal that's Shawn's legal definition of FSMA. Make foodborne illness stop. Foodborne illness is what drove FSMA. Foodborne illness is what inspired Congress to enact FSMA. Foodborne illness is what inspired President Obama to sign it into law. And foodborne illness is what FDA is trying to prevent, right? Yes, we talk about chemical threats. Yes, we talk about undeclared allergens. But really, foodborne illness is what has been in the headlines since Jack in the Box and has really driven every significant regulatory change as it results to food safety, right? Foodborne illness, make foodborne illness stop. But here's the deal. FDA understood that if it was instructed by Congress to create a new law, they could write regulations that then in turn required food companies to have written food safety plans. But what is a written food safety plan? It's I should have printed off a picture of a stop sign or a speed limit sign. It's just a sign, and having a sign by itself isn't necessarily going to mean that individuals or companies are going to comply, right? We all speed. So the agency understood that the new regulations needed some teeth, and that's where we sort of introduce, right, this element of the United States Department of Justice, DOJ. And in 2014, DOJ and FDA released a statement, in essence, saying, listen, if a food company produces food products that make people sick, we are going to look very closely at the circumstances to determine whether there's a basis to bring enhanced civil or even criminal charges against those involved, and those being not only the company itself, but potentially the individuals who are in the company. And we've seen this tool employed by FDA and then referrals to DOJ in multiple cases, a lot of cases over the course of the last 10 years. Some have been very big and in the headlines. Chipotle is a good example, Bluebell and others. So this is an area where when we think about compliance with FSMA and the enabling regulations that have been published by FDA and enforced by FDA, this is an area where the agencies have decided to take this extremely seriously. And it's been an interesting journey. I'll just very quickly, just by way of background, after Jack in the Box happened, of course, there were lots of lawsuits that were filed. Then USDA imposed, in essence, HACCP on the beef and poultry industries. And once that occurred, we all recognized and also declared E. coli 157H7 to be an adulterant in raw ground beef. But there was this sort of disconnect because it was very difficult to produce raw ground beef that was sterile, right? It's raw animal product. And the products are actually, they carry federally mandated safe handling labels saying, although inspected and passed by the USDA, this product may nevertheless contain bacteria that can make you sick if it's mishandled or not properly cooked. So we had sort of an impossible standard of eliminating E. coli 157H7 from ground beef, right? But when it was there, we had to recall that product, and it was causing outbreaks. And what would typically happen in a ground beef outbreak is USDA would come in, kind of inspect the facility, and find some things that were wrong, issue a notice of intended enforcement, and then there'd be that regulatory ballet where the company responds and the agency replies, and eventually everything's fine, the NOIE is lifted, and it's business as usual. But all along, the company continued producing food. Nobody talked about criminal charges, right? It was just, hey, it's just part of the beef industry. And then once PulseNet came online and CDC was able to see outbreaks emerging real time, and we began seeing outbreaks associated with all sorts of other products other than ground beef, right? Basically every product in the grocery store. FDA looked to USDA and said, well, what does USDA do when there's an outbreak? They go in, they do an inspection, they issue an NOIE. In our case, it might be a warning letter, a 483. The company fixes this stuff, continues producing product, and it's business as usual. Well, PCA happened in 2009, okay? And the company was, as we all know, was shipping product that it knew to be adulterated, positive for salmonella. A whole bunch of people got sick. And even then, I think it took maybe a year or more before DOJ even got involved. And that was the moment between PCA, the headlines, and Bill Marler testifying in front of Congress and appearing on the Larry King show. Congress stood up a little bit taller in their chairs and said, listen, we're going to pass FSMA, and we're going to require that all companies that are selling FDA regulated food products fall under these new rules. And they required to have written food safety plans, preventive controls, and all the things that we're now doing, right? And that's where we get into the teeth, because the FDA didn't want it to be business as usual when it came to outbreaks. The purpose, the command, the expectation is that foodborne illnesses and foodborne illness outbreaks would be stopped in their tracks. And the best way to get there from the agency's perspective is to look very closely when people do get sick and or worse, and whether there's a basis to bring these enhanced penalties. So here we are, right? And traceability, of course, is an integral part of the new food safety regulations under which we're operating. So just very quickly, I want to this is by way of background. If we look at sort of the history of recalls, this is recalls, total product recalls. We see some spikes over time. This is going back the last 20 years or so. And we're at 557 last year. Okay, that's quite a large number of food product recalls. This includes dietary supplements, animal pet foods, and then also beverages. And I predict we'll see that the trends are going to continue to kind of go up. I just layered in here, the red is total recalls, blue is FDA regulated products, and then the green is USDA regulated products. And just by way of background, I mentioned PCA. We saw a huge spike in the numbers of recalls in 2009, which kind of triggered, right, FSMA. Boom, got passed in 2011, 2012. Enforcement was really starting. FDA had new tools, new commands, new authorities, and we saw the numbers of recalls jump. Once the FDA started doing swabathons in food facilities during visits and was finding Listeria and Salmonella in those facilities, that triggered a large number of additional recalls. We kind of peaked at 877 in 2016. And then we had a huge drop, of course, because of COVID and a new focus on COVID management as opposed to food safety. FDA wasn't inspecting facilities, and USDA kind of throttled back as well. And now we see the trends and the numbers beginning to start climbing. I predict as we move forward, they're going to continue to climb, probably at a very at an increased rate as more and more regulations come into play and we have enhanced enforcement. And that's just the trend in the food industry. I want to show this slide because this is really kind of gets to the heart of what we're talking about. if we look at the triggers for recalls, undeclared allergens, it says big 8, it should be big 9 now that we have sesame. 51% of all recalls are because of allergens, undeclared allergens. But look at this, 1 out of every 4 recalls is because of pathogens. Pathogens that can make people sick, pathogens that can cause foodborne illness outbreaks. 1 in 4. That's a huge number. And that's really what the agency is looking, right, to get ahead of with the new traceability rules. Decrease the numbers of people who are getting sick when pathogens do make it into the food supply. About 12% of all recalls are going to be because of foreign materials. And then the remaining percentage is just other issues. We know this. We're able to gather this information because of our food recall reporter. It's a great tool. I encourage you to use it. The only thing we ask is to acknowledge you won't use the data to profit for yourselves, but it's a great tool if you want to vet companies. You can type in a food company name and see if it's been involved in any recalls. Here I just did 2023, and every recall for 2023 you can dig in. If you're interested in whether a particular product has risk, you can type in peanut butter and you'll see what types of recalls were associated with peanut butter over the course of the last 2 decades. So it's a great tool. Just want to point that out. It's could be really useful from a food safety standpoint, and it's fun. If you want to know how many recalls were caused because of fingertips found in food, type in fingertip, it'll show you. All right, FDA's new era of smarter food safety, right? This is what Frank Yanis was really pushing before he left the agency. Retail modernization, food safety culture, tech-enabled traceability, and outbreak response. Now, if you think about it, FDA's new era of smarter food safety culture. Food safety culture, in my opinion, and in the FDA's opinion, is going to be one of the most important things in making our food supply more safe. Food safety culture drives everything. Culture drives the amount of resources that we dedicate to solving issues. It drives our decision-making with respect to how and where and when and how frequently we're going to sample either our environment or our finished products. It drives who we partner with when it comes to our suppliers. It drives our decision-making internally when we might have an issue or there's risk, where we have to decide, do we release this product? Low risk, but super high cost, right? Culture drives everything, and culture is going to be one of the main drivers of food safety. That's a very important pillar. But why do we care about food safety culture? Because it's the one thing that is going to help us make foodborne illness stop, right? Make foodborne illness outbreaks stop. So food safety culture is all about preventing foodborne illness. Tech-enabled traceability, all about containing, right, the circumstances that lead to foodborne illness outbreaks. If FDA, CDC, and FDA catch wind of an emerging outbreak, a cluster of illnesses, and they can immediately, not days, not weeks, not months, but immediately figure out, okay, what did that consumer buy? Go back to the source and stop it. Think about the numbers of illnesses that are going to be prevented. Typically, it's a month or more, right? When a cluster is identified, maybe 3 or 4 months or 6 months before, and some are unsolved. But a lot of time passes because we just can't figure it out. Tech-enabled traceability is going to help tremendously. And then outbreak response. These 3 pieces, right, of the puzzle, the triangle, culture, traceability, and outbreak response. This is the 4 pillars. This is what FDA is all about, making foodborne illness stop. And the principles here are so important to understand because this is what drives the decision-making of the agency when it comes to regulatory enforcement and perhaps enhanced penalties for food companies, right? 3 of the 4 pillars, well, all 4, but these 3 are just laser pointed at preventing and containing foodborne illness outbreaks. Okay, so in the old days, right, traceability, and I guess this thing still exists today, 1 forward, 1 back. That's all we have to worry about. Who did I get this product from, and who did I, when I used it or that ingredient, who did I sell my finished product to or my ingredient to? That was it. And it's really kind of simple, right? And everybody can have their own system, and we don't have to really talk to each other. We just have to kind of worry about our four walls, what's coming in and then what's going out. But now, right, the entire supply chain is going to be involved. Imagine when I was in kindergarten, we played a game where you'd have, one person at the end of the line would be told something, and then they'd have to tell it to the next person, they'd have to tell it to the next person, they'd have to tell it to the next person. And then at the end, you'd see if the last person said the same thing that the first person was told, right? But that's what this is, right? Everybody has to be involved. Everybody has to be communicating each step of the way with respect to traceability, so that those lot codes, right, or the codes that we develop can help us figure out, okay, with respect to this finished product, where did it originate from? And super, super important. So everybody in the supply chain is going to be involved. Now, when deciding what foods that the FDA wanted to put on the food traceability list, it was driven by what? Oh my goodness, look at this. Number one, frequency of outbreaks and occurrence of illness. Why? Because FSMA is legal, Shawn's legal definition is make foodborne illness stop, FDA, right? Frequency of outbreaks. This is the driver of the foods that are on the list. Severity of illness, likelihood of contamination, etc. So this is, FDA is pretty serious about this stuff and is taking this very seriously and considers it extremely important, again, in preventing illness and containing outbreaks. Here's just a slide that shows all of the food products. We don't need to get into detail, but we've got cheeses, nut butters, PCA, right? Cucumbers, herbs. We'll talk about cucumbers in a little bit, leafy greens. And the list goes on. These are all products that have proven over the years to be associated with foodborne illness outbreaks, right? Making people sick. And FDA wants to be able to trace these products and their ingredients back to their original source almost instantaneously, right? For the purposes and the policies that we talked about. Okay, so who does the rule apply to? Anybody who manufactures, processes, packs, or holds foods that appear on the food traceability list, right? So potentially everybody in this, not potentially everybody in the supply chain, to the extent that you're handling foods that are on the list. So we're all kind of subject to it. Now, on the FDA website, there are exceptions. You can dig in, get into the weeds, and see if there are any exemptions that might apply to you. But that is not the purpose of today's talk. Today's talk is really to talk about the legal consequences. But I'll give just a little bit more overview on the traceability rule, and then we'll dive into what bad things can happen to us if we don't achieve compliance. Lot traceability code, at the end of the day, this is what is going to enable the FDA to, in essence, trace a food product back to its original source. Here's some examples that the FDA highlights on its website that might be used by industry, but we'll have flexibility to kind of come up with our own system collectively that works for our supply chain. The rule kind of, it touches all of us, no matter where we are in the supply chain, from harvesting to cooling, if it's occurring, initial packing, first land-based receiver, if we're talking about foods from the ocean, shipping, receiving, transformation. And I'll just highlight this. The food traceability rule requires persons who manufacture, process, pack, or hold foods on the food traceability list to maintain and provide to their supply chain partners, right, everybody downstream, specific information, key data elements, or KDEs, for critical tracking events, CTs, in the food supply chain. This framework forms the foundation for effective and efficient tracing and clearly communicates the information that FDA needs to do what? Make foodborne illnesses stop. Make foodborne illness outbreaks stop. Critical tracking events, these are each of the events that would typically apply to foods, from harvesting, cooling, initial packing, we just talked about them, shipping, receiving, and transformation. And then the key data elements for each critical tracking event are these that are displayed on the screen. So the data elements are ultimately what's going to be shared amongst the different parties in the supply chain. The rule does require each of us to have a traceability plan, which would include a description of the procedures that we use to maintain the required records, including the format and location, description of the procedures we use to identify foods on the food traceability list that we manufacture, process, pack, or hold, description of how we assign traceability lot codes to foods, if it's applicable, and a statement identifying a point of contact for questions regarding the traceability plan of records. Now, one of the debates that's been happening, I don't know if it's really a debate, but the conversations that have been happening in the industry is, do we adopt our traceability program for all foods that we may receive or distribute, as opposed to trying to figure out which of our finished products might contain ingredients that are on the food traceability list, right? And if we're going to invest the cost into new traceability program and going to execute against that program, do we want to kind of have to pick and choose which of the food products we need it for? Or do we just do it across the board? And my sense is, and my recommendation is, do it across the board, all foods, because eventually, I would predict this is happening, right? Whether we like it or not, it's happening. The compliance date will arrive. We will be required to establish that we are in compliance with the rules. And once that success happens, the FDA, in my view, will expand, right, the rule so that we're covering not only foods that can cause foodborne illness outbreaks, but foods that have been associated with, for instance, all foods, undeclared allergens, or how about foreign materials, right? So all foods have some level of risk. FDA is just starting with the most risky, and eventually I predict will begin to include other foods. So let's get ahead of it. And if we're gonna spend the money, the resources, and the time to do it, and then pick and choose, we're going to create exposure and risk for ourselves if we make a mistake or we miss something. If we do it across the board, we're going to be far more, we're going to have confidence that we're compliant, if that makes sense. So that's my recommendation. Okay, here's an example of sort of the supply chain for cucumbers. I said we were going to talk about cucumbers. Here it is. Farm, harvester, we've got the KDEs for harvesting, KDEs for cooling, KDEs for initial packing and shipping, KDEs for receiving, transformation, shipping, goes on and on, right? Okay, great. Again, this isn't about how to comply, just a general overview. But that now rolls us into, I guess, the next part of the conversation, which is this part, the legal compliance, right? Legal compliance. What types of exposure exist for us as individuals and companies if we are not compliant by 2026, January of 2026? Well, there's three categories. There's regulatory, there's civil, and there's criminal exposure. And I think this is very important when I have conversations with my clients in the C-suite. We talk about, okay, here's, if we want to kind of look out on the horizon and visualize, what are the consequences to the company? What are the consequences to the brand if we're not in a position to establish compliance, to have that conversation and say, okay, well, here are the things that could happen. And that also helps sort of drive the discussion into, okay, what are the resources that we're now going to begin to commit to this, whether it's additional employees, whether it's monetary, investing in a particular system, may have to make changes internally. We have to reach out and engage with our suppliers. We're going to have to engage with our customers. Like, all these things have to happen. It all takes time, right? But when we talk about, and unfortunately, this is a part of driving culture, right? Well, what happens if we don't have a good food safety culture? What happens if we don't have tech-enabled traceability? What happens if we don't, if we aren't putting the pieces in place to ensure that we're doing our part in making foodborne illness stop, or helping FDA in its efforts? What does that mean for us in the company? And that is a very good place to start when you're trying to drive change within an organization. All right, so cucumbers. Why are cucumbers on the food traceability list? Again, because FDA was commanded by Congress to make foodborne illness stop. Between the year 2000 and 2020, at least 41 cucumber-associated outbreaks were reported by CDC, causing 2,401 illnesses, 323 hospitalizations, and 7 deaths. Okay, that's why cucumbers are on the food traceability list. So what happens, right? A consumer purchases some cucumbers from the grocery store, supposed to be good for you, supposed to be healthy, but in this case, they're not. They become infected with salmonella. There's been, in the last 20 years, also an outbreak associated with E. coli in cucumbers. They get sick, they end up going to the hospital. CDC identifies a cluster along with FDA. They investigate and say, okay, here's, I think this was a cucumber outbreak from 2014 or 13. They say, okay, we've got our epi curve, sore thumb, right? Yeah, like that. We got our epi curve, and we know that all these people are getting sick. What's the common source? Local, state, local health departments will interview those case patients, and they'll figure out what they purchased. Ideally, in this cool new world, right? Oh my good, look at that. We've got this new traceability lot code that's compliant under the Part 204. Fabulous. And what can FDA do? Instantaneously go back and figure out where those cucumbers came from. The field, down to the field, right? Instantaneously. Boom, outbreak solved. And this particular outbreak, maybe they could have done that, you know, on July 22nd, as opposed to September 16th. And perhaps a lot of people's illnesses could have been prevented. That's it. This is simple, right? Traceability is critical. But what happens if, fast forward to 2027 or even 2026, and a food company does not have, is not compliant? Let's say it's a retailer doesn't have the required code for that particular product because they didn't receive it from the distributor, who didn't receive it from the produce processor, who didn't receive the information they needed from the initial packer, who didn't receive the information they needed from the cooler, etc. What happens? We got an outbreak. A couple hundred people are now sick. Maybe a small child is dead. And FDA says, hey, show me and they figure out there's a association, a hypothesis they're exploring with cucumbers. And they say, show us the code for this product. And it doesn't exist. Well, first off, FDA is going to have egg on its face. And it's going to be extremely frustrated in the early days because it's going to have to chat with the consumer, then visit the retail food establishment, go through their records, then track down to the distributor. They have to send their people out to the produce processor. They're gonna have to send more people to the initial packer. They're gonna have to send more people to the cooler if they can figure out where it came from, more people to the harvester, and then eventually the farm, spread out on the farm and begin testing water. And weeks and months will go by. And it all could have been prevented had the supply chain just done what it was expected to do, right? So here now we're in the situation where the FDA has to figure out, we've got an outbreak, we have at least one death, hundreds of people have gotten sick, and although we put this regulation in place, although we gave companies 4 years to figure it out, it didn't happen. Now I can promise you, the agency won't just stand by and kind of shrug its shoulders and say, oh, well, can you please maybe try to do it better next time? It just won't happen. FDA, as much as it is a regulatory agency, it's also a political agency. And there's been a lot of time, a lot of effort, a lot of work into unveiling and then finalizing these rules. So this is a scenario that none of us ever want to be caught up into if we're in this supply chain and we cannot establish compliance on the heels of a large outbreak that is making people sick. So before we talk about the regulatory consequences, I just want to mention quickly the civil consequences from a civil standpoint. That same scenario, let's say we've got a couple hundred people who are sick, we have a death, and plaintiff lawyer like Bill Marler is called by the family of the child who has passed and says, hey, will you please represent us? We lost our child because who was recovering from leukemia and ate cucumber contaminated with salmonella. And Bill says, yes, of course I will. In the old days, Bill could kind of pick and choose who he wanted to target. Here I just have the produce processor. When contaminated food was sold, typically he'd sue the retail establishment, who would then bring in the distributor, who would then bring in the food processor, who would then bring in the packer, etc. Usually the farm is left alone, and the harvester, but that's how this would play out. But now, because, and we used to say in the business, and I spent my entire career defending high profile foodborne illness claims, we'd look at the distributor, for instance, be like, they're just a pass through. Nobody really focuses on the distributor. Nobody really cares from a civil liability standpoint who put the E. coli in the ground beef, right? Or who processed or repacked the contaminated produce. But now everybody in the supply chain has a legal obligation and a duty to the consumer to ensure that they're doing what they're required to do under Part 204 and collecting and then passing on the required information. And imagine a scenario where an outbreak could have been solved by FDA on July 2nd if the appropriate traceability code was accompanied the product, because everybody in the supply chain did what they were required to do. But there were failures, so that code didn't exist. And the consumer in this particular example purchased the product a month later on August 2nd and ended up getting sick and dying. And the reason why that product was still on the market is because the FDA didn't have the ability to trace back immediately, instantly, right, to find the original source. So and that opens, I think, exposure for companies, anybody in the supply chain, to liability, right? But then also potentially punitive damages. Say, listen, you company A could have done X, Y, or Z. You failed to do so, and as a result, we have a death on our hands. So from the civil standpoint, it kind of changes the dynamics of foodborne illness outbreak defense and the claims that can be asserted by plaintiff lawyers against really the entire supply chain. So I think that's it can be a bit nuanced, but it's a change for sure. If we get into the regulatory, the point I want to make here is these consequences apply whether it's triggered by an outbreak scenario like we just talked about, or potentially moving forward a routine inspection. Now, I can assure you that on a routine inspection, FDA still will not be happy if a company has not achieved compliance, but the consequences are likely going to be somewhat different. So we'll talk about them. So, Form 483, if we're not in an outbreak scenario, nobody's gotten sick, nobody's dead, likely the agency would issue a Form 483 to the company or a letter saying, listen, you better get in compliance quickly. You have, X amount of time, 15 business days to respond. And we better be satisfied by what you tell us. If a company continues to demonstrate non-compliance or hasn't even tried or can't establish that it's working diligently towards compliance, or the response to the Form 483 isn't sufficient, we could see that being elevated to a warning letter to the company, which can threaten a number of things, including debarment or disqualification or even a suspension of the food facility registration. All of these things are in the FDA's toolkit or injunctions to prevent, in essence, to tell a company, because you're not compliant with the traceability rule, we're not going to let you sell or distribute food, period, until you can establish compliance, right? So I think, the inside baseball, talking to my friends at FDA, what I'm being told is the compliance date is January of 2026, although the agency won't begin any enforcement actions until 2027. So there's going to be a little, I think, the educate before we regulate approach, but that will not apply in the case of an outbreak. Now, I'll tell you right now, if April of 2026 there's an outbreak, and in this supply chain we have a scenario where the traceability lock code doesn't exist, the FDA will come down with a very, very heavy hammer. Could be immediate suspension or disbarment. I do not see the agency allowing the supply chain not to be in compliance while witnessing and trying to solve an outbreak, right, when they are supposed to be in compliance. So there's going to be that area where there could be some significant consequences. But once we get into, once FDA makes a decision, listen, we expect the entire industry to be in compliance and be in compliance right now, the consequences could be pretty strict, including the suspension of any food facility registration for warehouses, or even preventing companies from marketing their foods until they can establish that they've fixed the problem. All right, and then that rolls us into criminal park doctrine liability. Criminal park doctrine liability. So park doctrine, this is an area, we talked about it earlier, where, FDA and DOJ have sort of nodded their heads and said, listen, we're going to work together in those circumstances where a food company produces or sells food products that make people sick, or people get sick in an instance that could have been prevented by a company in the supply chain or companies. Now, the park doctrine stems from a 1970s case where John Park, the CEO of Acton Grocery Stores, was in essence overseeing not only grocery chain, but numerous warehouses. And FDA went in and conducted an inspection of one of those warehouses and found evidence of rodent droppings on the floor next to a pallet of case product. The FDA addressed its 483 to Mr. Park, expressing its displeasure to its observations, and the FDA expected that those observations would be rectified. FDA went back to the warehouse a number of months later, and they saw once again evidence of rodent droppings on the floor next to a pallet of case product. FDA then referred the issue to DOJ, who brought criminal charges against John Park for his failure to fix the conditions observed by the FDA, the insanitary conditions. John Park argued, hey, listen, I have a vice president of regulation who is responsible for that. I delegated that to that person. They failed to do it. There's no basis to charge me as the CEO of the company. And the case made its way all the way up. He was convicted. The case made its way all the way up to the Supreme Court. The Supreme Court sided with DOJ and said, listen, you are in a position and you have the obligation and responsibility and ability to correct those types of insanitary conditions. And when it comes to food, which is really important to all of us, the expectations are even heightened, and they upheld the conviction, which now is known as the Park Doctrine. Also referred to is responsible corporate officer doctrine. And I'll just read you what I have here. A corporate official with authority and responsibility for supervising subordinates may be held criminally liable without a showing of affirmative wrongful action or intent for a subordinate's violation of a public welfare statute that contains no requirement of intent and carries only misdemeanor penalties. The principle has become known as the responsible corporate officer doctrine. Okay, so no showing of intent, strict liability crime. And I'll paraphrase the elements for you. So number one, and this is what the government would have to prove to get a conviction, the defendant is aware of a condition that could lead to product contamination. Okay, awareness of a condition. And that could be listeria in the environment, food processing facility. That could be not having a traceability plan as required by the regulation. That could, I'll say, could lead to product contamination or people getting sick. Second element, the defendant is in a position to eliminate the condition, right? Eliminate the listeria from the environment, or put a traceability plan in effect so that if an issue is identified, FDA can contain it immediately and it doesn't persist over the course of weeks or months. And the defendant fails to eliminate the condition. Okay, so we're aware of a condition that could lead to people getting sick. We're in a position to solve it. John Park was in a position to make sure that the rodent droppings were removed from the warehouse floor, and he failed to do so. That's it. That's all the government needs to obtain a conviction. And the penalties are pretty severe, up to a $250,000 fine per count or a year in prison per count. And if you think about, every ice cream cone that was distributed, or every person who got sick as a result of the defendant's failure to do what was required, that could add up to a lot of years, either in jail, prison, I guess, or a lot of monetary penalties. And we've seen DOJ use these tools against not only food manufacturers, but also retailers as the FDA, spreads its jurisdictional wings over not only food production, but sale at retail establishments as well. So agency has a lot of power. And with the teeth of the Park Doctrine, it's very easy in a circumstance when people become sick for DOJ to at least threaten and bring charges, seek penalties against the company itself or even individuals within the company. There was a circumstance, and this isn't just corporate officers. There was a matter that was recently resolved with DOJ and a company where DOJ obtained brought charges against the plant manager, and the defendant pled guilty in that case, a plant manager. With PCA, we saw lower ranking individuals in the company who were also charged in that circumstance. So the point here is with Park Doctrine liability is none of us want to be in a circumstance where, middle of 2026, there's an outbreak associated with the product that either we sold or we were part of the distribution chain, and we don't have this traceability requirement satisfied, because this is what, our exposure could potentially be. And this is, I think, the conversation internally with the company's leadership, in your organization to talk about, say, listen, yeah, it's kind of unlikely, but, never say never. If this were to play out this way, this is the type of enhanced exposure we may have, and it isn't necessarily just going to be a light tap on the wrist, right? So I think I've seen a lot of companies tremendously hurt or even forced out of business because of the unexpected happens, right? So that's the point here, is we don't want to find ourselves in a circumstance where we could be targeted by FDA with a referral to DOJ because we didn't do what they asked us to do beginning in 2022. Okay. And then just on the mock, we do mock foodborne illness trials and mock traceability criminal trials with a lot of our clients. Usually the circumstances is a case involving a fictional convenience chain selling a fictional veggie wrap product. And the exercise, it's actually really useful. I just throw this out there because it's really been embraced by a lot of our industry partners. But we have my colleague Joel Chappelle will play the role of the DOJ prosecutor. Oops. I will play the role of let me just see. I'm not sure what happened there. DOJ prosecutor. He'll try to convince the jury as to why this particular company and or the individuals in the company should be held liable for failing to have the requirements satisfied in the context of an outbreak where you have a death. And then the audience would serve as jurors and actually deliberate the case and make a determination whether the individual was guilty or not guilty. We do this in the foodborne illness context. We also do it in the traceability context. The exercise takes about an hour and a half, and you'll probably see it at a food safety event at some point. We do it there as well. The point here is it's so important to have a conversation with your company leadership to talk about the full spectrum of risks, so that ultimately when decisions are being made about when to get started with compliance, and I would say it should be now, and what resources to allocate towards compliance, that everybody is seeing the full picture and fully informed and being able to make the right decision. So with that, I want to thank everybody for your time today. I really appreciate your joining us, and I think we have a little bit of time for questions.
We do. All right. Thank you, Shawn, and thank you to those who have submitted questions as well. If we are unable to answer your question live, we will reply to you personally with an answer. But Shawn, I wanted to let you know that we do have a special guest here who's joined us to help with the Q&A portion of today's presentation. ReposiTrak Chairman and CEO Randy Fields is here. So Randy.
Wow. Thank you. That's a really nice, honorable introduction. Shawn, thanks. This was, to me, it was astounding. And We like it when people bring up, let's call it, issues that others have not thought of on behalf of our customers. So this was really extraordinary. I have 2 or 3 questions, and I think they're relatively simple. Let's give it a try. Many of the people that we're interacting with are what we would call independent grocers, meaning that the bulk of their product, 60 or 70% of the product that they sell, and they may only have 1, 5, 10, 20 stores, comes to them through a wholesaler. But the balance of their products comes through a process called direct store delivery. I know that you're familiar with that. Many of them believe that they're going to be okay if they ignore the direct store delivery stuff and just make it the responsibility of their wholesaler to take care of gathering information. Do you have some thoughts on that? So there's really 2 parts to it. One, the idea that I'm not going to do anything, I'm going to make my wholesaler do it for me to try and shift the responsibility. And then the second is, what happens if a problem arises from a direct store delivery product, like a dairy product, fresh eggs, things like that that are on the list, or even produce that comes directly to the store? What could happen to an independent retailer that takes that position?
Yeah, I think that's a great question, Randy. And I think the title of this presentation really speaks towards that, which is traceability has changed everything. With most food safety regs, we're focused really on what's within our 4 walls. We get to supplier approval for manufacturers and that kind of stuff. There is some blending where we have some responsibility for who we're purchasing from. But generally speaking, if thinking about preventing listeria contamination in a product, that responsibility belongs to one entity, usually in the supply chain. And it's okay for retailer, well, it's not okay, but retailers might say, listen, I'm buying cucumbers from this distributor, and it's up to the distributor to make sure that they're safe, and I can presume that they're safe. And if somebody gets sick or there's an outbreak, I'm just a pass-through, right? So I don't really shoulder any liability, and that's generally true. With traceability, what's changed is the FDA has pointed at the retailer, at the supplier, at the ingredient supplier, at the harvester, at the distributor, and then at the farmer, and said, each of you are required to do X. And that's the difference. So I think in the example that you shared, the retailer, FDA has pointed its finger at the retailer and said, we expect if there is a product on your shelf that falls within the purview of the food traceability rule, you will be compliant. And if you're not, right, all the legal consequences that we've talked about can cascade down on that particular entity, and the agency will pull out a big hammer and use it. And I think the instinct might be from the retail perspective to your point, kind of push the regulation away and be like, yeah, that's somebody else's responsibility. But I think the way this plays out in reality is the FDA would likely come down first and heaviest on the retailer, because the retailer is in essence gathering all of these products, right? And it's sort of the last stop. So if the retailer, the agency, I could see saying, listen, and to create a deterrent to others, it may penalize the retailer extremely heavily so that to ensure that its supply chain is compliant, so that other retailers do the same thing, right? Because retail at the end of the day is the one selecting which products it wants to buy and put on its shelves and exposing the consumer to that. So I could see the FDA coming down very heavily on a retailer for not taking all those steps it needs to ensure that its supply chain is compliant, and not allowing a retailer to say, listen, it's just somebody else's responsibility, I don't have to worry about it, if that makes sense.
Yeah, that's a really extraordinary point. It obviates about 5 other questions I have. But if the retailer is on point and he has a supplier that's non-cooperative, let's say, to giving him the traceability records he needs, it sounds like what you're saying is that the retailer should probably replace that supplier, that he can't
Absolutely.
shrug his shoulders to the FDA and say, hey, not my fault. Is that correct?
Absolutely. Absolutely. Yep.
Wow.
It should be a mandatory requirement to have that traceability plan in place. And, there's going to have to be, everybody has to work together, right? Because it's a supply chain. But same as with, if I've got a supplier who doesn't want to sample the ingredients that they're shipping to me that I'm going to use in my finished product for Listeria, I don't want to do business with that supplier, right? I'll move to somebody else. And I think traceability is the same
Very
principle.
interesting.
Yep.
Well, there's one other question, then I'll shut up, but it's adjacent to this, which is, as a retailer, how will I know if somebody's changed an ingredient and the new ingredient is we'll call it a 204 ingredient, or I just don't know that something has a nut butter in it because there's thousands of products with nut butters. Is that really at the base of why you're suggesting to people it may actually be easier and lower risk to do all food as opposed to trying to figure out what is and is not 204 product?
Absolutely. I view it as being extremely difficult and fraught with risk because inevitably you're going to miss something. Somebody in the supply chain, the communication. I mean, we can't get it straight with undeclared allergens, right? You think about all the recalls for undeclared allergens, just because there's just so much complexity and so many moving parts, and it's so difficult to get it right. And if you're trying to slice out just, particular products, there are going to be lots of mistakes. And we're going to, I would say we would increase our exposure significantly because it never fails. It's going to be the one product for which somebody missed that is now responsible for an outbreak, and we don't have the required information. So, and then the second part of that, Randy, and I mentioned this earlier, is I truly believe there will come a point in time, maybe I'm retired by then, but there will come a point in time, and I'm thinking about retirement relatively soon, but there will be a point in time where the FDA will have the same traceability requirements for all food products.
Wow.
There's no doubt in my mind.
Wow. Shawn, this is really a public service. What you're doing is so important to the industry. Thank you. Thank you.
Of course.
Thank you, Randy, and thank you, Shawn. We do have a lot of questions that have come in from the audience. Shawn, if you have maybe 5 more minutes, or do we need to wrap up? You okay?
Yeah, we can spend a couple of minutes. That'd be great.
Okay. All right. I have just one. And actually, Randy, while you're still on the line, maybe you can help with this one too. So the question is, why haven't I heard about compliance from Walmart and Kroger yet? What do you know about their next steps?
So I'll just high level, companies are working and or should be working to try to figure out, okay, how are we going to get there? And there has been some musings. I'll let Randy kind of speak to some of that, but we're kind of at the point where people are realizing, the industry is realizing that, okay, we thought we had this cushion of time and we don't anymore. And the water's starting to boil. Let me put it that way. Randy, do you want to kind of fill in the blanks?
Yeah, absolutely. We have heard from Kroger. Kroger announced December 1st of last year that they're going to require traceability for all food items from all vendors. So Kroger is out in front, and they also moved the deadline up for compliance. So Kroger has put a stake in the ground that by June of 2025, what's that, 14 months away, all of their suppliers that sell food will be traceable. But our guess is, and we're certainly hearing rumblings, that there's some other retailers that are beginning to make decisions. One of our customers, a wholesaler, made the decision in January that same thing, all food items will be traceable. So you're certainly right about the trend here from our perspective, Shawn. We're seeing retailers and wholesalers giving up on the idea of figuring out which items that require traceability, just saying it's easier to do everything, and it's certainly safer to do everything.
Well said.
Great. Well, there are a list of questions that we will have to take offline just due to the time, but I wanted to thank you, Shawn, and also thank you, Randy, for joining. And to the audience, you will receive a recording of today's webinar along with the slides within 24 hours. So thank you very much.
Yeah, and to everybody who has a question, we'll get responses out to those via email. So I'll just thank you in advance for submitting those, and like I said, we'll make sure we respond.
Okay. Thank you very much. That concludes today's event.
Thank you, everybody.
Bye.